Greetings, class. I am recording these videos about the chapter on constitutional law, or it's titled Constitutional Basis for Business Regulation. I'm kind of pointing out the highlights of the chapter. It is a very complicated chapter to understand, so that I would just, you know, ask you to use this as a guide for reading the material. It's not meant to be a substitute for reading it. So let's go ahead and get started with it then. I want to start with an example. Let's say the governor of Nevada filed for an injunction to prevent any shipments of uranium by the U.S. Nuclear Regulatory Commission to the nuclear waste repository in the Yucca Mountains. When the court denied the injunction and held for the NRC, the governor issued an executive order prohibiting any transportation of uranium on state roads. The NRC moved for injunctive relief against the governor. What should a court decide and why? So I'll give you a minute to think about it. So if you want to pause the video to think about what you think the court would decide, take a minute to do that. The answer is that the governor loses the case. Even though the governor is concerned about his citizens and how they may be impacted by nuclear waste being transported through the state and being stored in the state, under the principle of preemption, which is what I have listed as the title of both of these slides, the federal government takes priority over the state government. So if you see the picture that I have in the lower corner of the slide, I have the federal government as a big person there and the state government in red as a little person, and the big person is about to step on the little person. And that's what I want you to remember, is that when you talk about preemption, as long as the federal government is acting within its enumerated or implied powers, the federal government prevails. And that is consistent with the supremacy clause. So as you read through that in the book, think of this. The book does have a case, Geyer versus Honda, and that's another case that involves determining who has priority over the specific area. Under the Constitution, we have separation of powers as a key principle. It's designed to provide checks and balances. We have separation of powers in the federal government and how it's structured. We also have separation of powers in the state government. So both the state and federal governments each have these three branches. You have the executive branch, which in the case of the federal government is the president and the president's cabinet. The legislative branch, which is Congress, in the case of the federal government. And the judicial branch, which is the judges. In the federal system, the highest judges are the United States Supreme Court judges. I have, if you look at this diagram that I've placed here, the judicial branch, the words are bigger and they're in a different color. And I did that on purpose because I wanted to illustrate that it's the judicial branch that ultimately determines whether the executive branch and the legislative branch are performing their duties or whether they're acting outside of their duties. We also have administrative agencies, which I didn't list here. Administrative agencies, which we'll look at in a later chapter. They are not official branches of the government, but some call them unofficially the fourth branch of government, because of the power that they have. Anyway, going back to the judicial branch, it was in Marbury versus Madison that the judicial branch said, well, if we need to interpret whether something is constitutional or not, the judicial branch is the one that does that. And so that's why you have groundbreaking Supreme Court decisions, because it's the judicial branch that ultimately determines constitutionality. It ultimately determines whether the other two branches have acted outside their authority. Now, federalism is a principle that you'll see discussed in the chapter, and that has to do with the federal government's priority over state government. And if you look again, I have the same graphic that I had earlier with the Nuclear Regulatory Commission case in the state of Nevada, and that is the federal government's the big person in the black, or all black, and then the state government is the little person in red. And that's representing how the federal government has priority over, preempts, has supremacy over the state governments. As long as the federal government was acting within its enumerated powers, then that is the case. And those enumerated powers include powers related to the power to tax, the power to regulate interstate commerce, which we'll look at in a minute, and other powers that are specifically listed in the Constitution. We also have the principle of dual sovereignty, where we have both state and federal government, but again, the federal government prevails. Now, the book spends some time talking about the Commerce Clause. The Commerce Clause is Congress's power to regulate commerce with foreign nations and among the several states and with the Indian tribes. And that's the specific language of Article 1, Section 8 of the Constitution. And the book spends quite a bit of time talking about the Commerce Clause because obviously it's related to business and business law. The U.S. Supreme Court, through the years, and again, read through this in the book, has moved from a very narrow definition, definition of what is commerce to a relatively expansive definition of what constitutes interstate commerce. Generally, using channels and facilities of interstate commerce constitute commerce. And then in the case of interstate commerce, commerce are activities that affect more than one state. As a practical matter, if you look at those definitions and look at how the court has expanded the definition, almost any business would be considered as being interstate because it either is directly involved in interstate or indirectly affects interstate commerce. The Patient Protection Act, you have the Florida versus U.S. Department of Health and Human Services case on page 95 that talks about what the circuit court did. And the circuit court is a lower court than the U.S. Supreme Court. And we will talk about the U.S. Supreme Court decision probably in our Illuminate sessions in October. That's a key part of what we'll be talking about off and on in the course. Now, in this next slide, I look at the federal and state powers to regulate commerce. And here I do list out the federal enumerated powers. So the graphic is designed to show that black center, those are the enumerated powers of the federal government. They enumerated in Article 1, Section 8. They include interstate and international commerce, immigration laws, the power to coin money, the power to tax, the power to borrow money, the power to spend money. There are others as well. These are just examples. The implied powers then are what are sort of reasonably necessary to carry out these express or enumerated powers. And so that's why on this graphic that I've given you, you have kind of this haze that's all around the enumerated powers. The enumerated powers are where Congress's specific power is, but the implied powers kind of arise from those, and that's what that haze represents. So getting back to commerce then, the federal government has the exclusive power to regulate interstate and international commerce and commerce among the Indian tribes. The power that states have to regulate commerce only comes from whatever is not covered by the federal government. That would be purely intrastate activities, commercial activities, or those activities where when the state regulates it, it has minimal effect on interstate commerce. If, though, a state passes a law that's really protectionist, courts will not uphold those laws. So states that want to pass laws that are different than federal governments in the area of commerce have to be very careful to clarify the intent of the law. What are they trying to do? If it looks like they're trying to protect intrastate businesses at the expense of interstate businesses, then the courts will strike down the legislation. The other thing the courts will look at is there another way to accomplish the same thing? In the book and the slides, the question is whether there's a less discriminatory alternative to accomplish the state purpose. The state's police power is the state's power to pass laws to protect the citizens' health, safety, and welfare in that state. So sometimes the state does want to regulate commerce in an effort to protect those citizens or to promote their health. But if it's seen as purely protectionist and it's harmful to out-of-state businesses, then the courts will typically strike the legislation down. So what is purely intrastate businesses? Almost nothing. On the slide, I say purely local activities are what are exclusively within the state's power to regulate. It is very rare. The picture that I put on the slide is a picture of housing. Housing or real estate is generally considered purely intrastate, even though we know that a lot of the activities are conducted using instrumentalities of interstate commerce like telephones and email and all that stuff and mail. It's still considered purely intrastate. But other than real estate, you really don't have anything else that's purely local. It would be very rare. So that means the federal government does have the power to regulate business, and businesses have an obligation to comply. Now, typically what the federal government does when it regulates a business is it will set a minimum size below which businesses don't have to comply with the federal regulation. So you'll see legislation as we go through the semester where the federal legislation will say an employer that has 15 or more employees. And so if you have 14 or less than that, then you wouldn't have to comply with the federal regulations, but of course you would still have to comply with state regulations. So that's a real quick summary of kind of the first part of the chapter. In the other two parts, I will talk about other aspects of constitutional law.